Hello, my name is Matthew Talbot, and I'm coming to you today from Walnut Creek, California, in the Talbot Law Group, where we focus on estates, wills, trusts, conservatorship matters. And I want to talk to you about the mediation process, because a lot of people don't even know what a mediation looks like. As I've indicated in other videos, mediation is a voluntary process by which the parties to a lawsuit get together to try to resolve their problems and come to resolution on their lawsuit with a mediator, a trained professional who can help bring the warring litigants together. So usually with a mediation, it may start with a joint session. A joint session is where everyone gets together to go over ground rules and maybe exchange information about the case. These days, everything's online, so the joint session is through Zoom, but it may be, again, that we end up with in-person joint sessions. Sometimes people use the joint sessions as a way to talk through problems, and I have seen cases where people apologize for nasty language or get things off their chest that allow the mediation to be very successful in the joint session. I've also seen situations where there can be some antagonism. So sometimes the joint session has to be tightly controlled or is not even in the best interest of settling. It really depends on the parties, and every case is different. After the joint session, whether it's a long, emotional conversation or whether it's a short, ground rules focused conversation, the parties will usually go to their own rooms, called caucuses. And again, this is all online these days, but it may be again very soon that it will be in person. And then the mediator and other attorneys will sometimes shuttle back and forth between the rooms to discuss resolution. Parties like to be private when they discuss resolution so they can talk openly with their attorneys and they can discuss whether or not they have a good case or a bad case, different issues in the case, how they feel about those issues, and how they feel about settlement. These types of conversations can't really occur openly if the other party is in the room with you. So oftentimes you'll have 2, 3, or even more rooms where the parties are stationed to discuss their case, and the mediator and other attorneys and professionals will go back and forth to shuttle information. So the mediator may start in one room with an offer. I'll pay you $10 and you drop your case. Then the mediator goes into the other room and comes up with a counteroffer. Pay me $100 and I will settle my case and drop my case. And you can see how the mediator can ping pong back and forth between these rooms to come to resolution. They might come to resolution at $50 or $60. Sometimes the situations are more complicated than merely paying money, and it may involve the care of an elder. It may involve interpretation of a will or a trust where the language is vague or confusing. There's many, many different issues, and I've been involved in innumerable mediations in the past 14 or 15 years of my career from all angles. And so my focus when doing a mediation is trying to help facilitate as much information sharing as possible so that all parties know where everybody stands. In this information sharing process, it's like putting your cards on the table in a poker game. Some attorneys don't like to do that, but I think it's imperative so that you can get a good judgment on whether you have a good case or whether you have a bad case. And then you can come to resolution based on that. So at the end, there will be a settlement that usually is drafted and signed by the attorneys. And even this can take some time. As they say, the devil's in the details. And I've had many cases where you get a resolution by 2 or 3 in the afternoon, and you're still at the mediation hours later going through the finer details of the settlement. Some mediators use term sheets, where the general terms are drafted out, signed, and then the much longer settlement agreement is drafted later. However, I've had many experiences where that becomes problematic because people interpret the terms of a term sheet differently, and the language of the settlement itself and the agreement itself ends up in dispute, ends up in fighting. So I think it's very important in the mediation process to have a signed, multi-page settlement agreement at the end of the day to ensure that there's no more fighting, that it's put before the court, and completely resolved without issue. So if you are interested in resolving your case, minimizing stress, and minimizing cost, don't hesitate to reach out to the Talbot Law Group to see how we can help you. Thank you so much.